All right, so we're going to try something a little different. My camera just blew chunks, so I'm going through my laptop. Hopefully the quality is okay. It's the information, not this face that you want to see anyway. So I'm going to be trying something different. I'm going off my laptop and my desktop at the same time, but to bring you better quality information as opposed to maybe not so good quality video. Enough of this. So today is new assignment and securitization case. I wasn't going to do this, and then someone hired me to do another Galaxy International case, which, all right, but the documents they attached, and I don't normally do a lot of Galaxy International, but suddenly I'm Galaxy International purchasing, and suddenly the light went on when I looked at what's called their certificate of loan sale. So you'll see that coming up soon. So when a debt buyer, which is Galaxy, buys the debt, it relies upon whatever it buys from the company. They paid pennies on the dollar for the stuff. So, and usually that comes with a forward flow agreement that says we're going to give you the paperwork, but we're not making any presentations or warranties on this stuff. It'll sometimes say it right in their own documents. And a lot of times it'll say without recourse, means you can't sue us on this, Drek. So that's pennies on the dollar paperwork. So oftentimes the debt buyer doesn't really worry about that, as I said in the past, because 90% of these lawsuits are going to get defaulted or settled early anyway. That's where you shine because of that haphazard, apathetical way of suing people. And you'll see in this case, for example, you are not going to see much care put into this work. So I give you Exhibit A. Here's the lawsuit from the law firm, and you've seen one of these before, that filed the lawsuit against my client, Shazam, and that's a couple of pages there. You can see it's it's a wreck. Um, I'm trying not to not look at the camera here, but the stuff I want to show you is cool. So I focused in my answer and my counter affidavit on paragraph 4, which essentially says, hey, we own it because it was transferred to us without any specifics. Now, why am I doing this particular one when I just did a couple of weeks ago at Galaxy International? Because this is where securitization comes in. You're going to see for the first time the mix of securitization, debt buying, not just talked about or researched. It's right in their certificate of loan sale. So let's check this out. So we're going to look at the exhibits. You can see on their sterile and benign lawsuit that there's just nothing there. It's a general deal, and that's good for you if you're not going to fall in the 90% default. I want to talk about that 90% real quick. Go look at as I always say, PRA versus Green case. The court will talk about how cases get defaulted at 90 and there's not such great care. But that, in this case or any case, it doesn't mean the person suing you abdicates from the responsibility of the standard of care, which is if you're going to use an assignment to show you own it, it's got to show the account number, it's got to show the name of the debtor, right? At a minimum, and certified, and signed off on. So this is another great example of that being ignored. So let's take a look at their bill of sale. Shazam. This is great, this bill of sale. I want you to look at the first paragraph. Lending Club, a Delaware corporation, and Galaxy International Purchasing in Nevada, Casino Land, executed an account purchase agreement, forward flow. You'll always see the word forward flows, or mostly always see it. That is the governing document. So there'll be more and more sales between these parties, and they'll go, look at the 2020 agreement, except you don't get that agreement. So if you're ever in a bind and it's not going your way, do a discovery request for their forward flow agreement. They don't want to show anybody that. And that may tip the scale of you settling. And I say that because they put it right in your bill of sale. So It's got to be something easily discoverable. So now so you see the terms of the agreement will govern this bill of sale in any capitalized but undefined terms. Herein will have meanings given to such terms of the agreement. What that means is there's no sale. Where does it say we are selling document A to party B or whatever? It's just saying we got an agreement. Where's the sale? It's titled bill of sale. So maybe I'm wrong. Let's look at the language below the paragraph. For value received in further consideration of mutual covenants, yada, 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 between the investors referenced in the data file, hereby transfer sale to buyer. Here it's called, but how did the investors get the debt that they're being told to sell to the buyer? There's no assignments. Don't discount that. If I sell you my car and then you give it to Bob and Bob says, I own it, Bob has to show you signing off and giving it to Bob, but you can't go register that. It's no different than a sale where you're going to sue somebody. So there's got to be something lending club to buyer, which is the plaintiff in this case. But this is going to get even better. Check this out. So this was signed January 22nd, 2021. You're going to love this. And it's saying lending club represents and warrants that each undersigned investors. Who are those? And investors. So where are the names? Where are the assignments between all these investors? Has executed a limited power of attorney between investor and lending club. So that's what this document is. It's not a bill of sale of anything. It's a power of attorney for lending club to act on behalf of the unnamed investors. Don't discount that either. There's no bill of sale here. So far, there's no proof that Galaxy International that sued my clients, a real case, has any ownership, responsibility, or evidence. So that was signed, if you look at the bill of sale, January 22, 2021. Here's the fun part. Oh, by the way, look at in this case that I've got on the screen, just a couple of the people that signed. Seller, LC Trust, 1. Seller, Lending Club Corporation. Seller, Consumer Lending Corp. LLC. Where's the assignments to these companies? These are signatures. They're not assigning anything. So, and there's no reference to this. It's just a mess, but they get away with it unless they're you or me. So that's January 22nd, 2021. Now look at the real fun stuff. Oh, before I do that, let me put on the board, Shazam, the video, some other signatures that are attached to this bill of sale. This is a real thing. There's 4 pages of this. Consumer Loan Trust, Consumer Loan Trust 4, Consumer Loan Trust 3, Consumer Loan Trust 6. You can see for yourself that these are trust related, securitized. But there's more. It gets better. So before we go and it gets better, where is the authorization for this gentleman, Brandon Pace, to sign for anybody? You must have that. You can't just sign it. It's not let's see, they say general counsel. General counsel of whom? The 150 trusts? Not likely. Or Lending Club or Galaxy or the investors. So it's all a bunch of, you have to have authorization and proof. There's nothing stated in that bill of sale about the actual specific debt, or the word debt, just loan or accounts. Number 3, as I said before, go back to what I said at the beginning. Where's the name of your debtor, my client, or you, if it's your case you're defending? Now, here comes the fun part. I keep saying, here comes the fun part. Certificate of loan sale on the video. I just love this. Maybe you don't get excited by this, but you should get excited because you're going to get out of whatever amount of debt. This, by the way, is over $25,000 debt. And I'm going to get the client out of it. I'm also going to show you the actual email that I sent to the other side. So more fun stuff at the end, all right? And you can use that if it fits your fact pattern and you're dealing with an attorney. So at the end, I'm going to give you the actual email to get my client out of this, along with my answer and counter affidavit. I said, here, I'm going to file a counterclaim if you don't settle this within 7 days. You'll see it at the end. But check this out. Shazam, certificate of loan sale. I love this. Look at that bad boy. Look at paragraph 3. I'll put it on. Let's focus on paragraph 3 and paragraph 4. Shazam. It says within 1 week of origination. What does that mean? That means within a week of they have lent the client money, the client signed the loan agreement, they executed it. That's the week of origination. Within 1 week, transferor, so let's go back up. Certificate of loan sale, the transferor is WebBank. That's the person that lent the money. Company. That's a big one, by the way, in Utah. Ooh. Anytime you see WebBank in your chain of title, you're done. You win the case. Trust me. So number 3 says transfer, transferred, or otherwise conveyed to Solar Gray Trust, each loan identified. So they're saying in their own document, we gave the debt to a trust. But look at how they say it, paragraph 4. Transferor, WebBank, conveyed to Solar Gray Trust all of transferor's, WebBank, right, title, and interest. In other words, if I want to give you something, that's not a half-ass giving you something. Everything you possibly give to someone, all the right, title, and interest, and here you go, in each loan. So there's no ambiguity. There's some left over here, there's some here, all the right, title, and interest. Why am I saying this? To the transfer to Solar Gray Trust. So Solar Gray Trust owns everything, all the loans now, right? So what? Well, look at who's this between. WebBank and Lending Club. This is designed to show Lending Club now owns the debt to go sell it to Galaxy. Look at the date. 127, 5 days after the bill of sale. So you can't retroactively. Lending Club has nothing to give Galaxy 5 days earlier, right? Why are they relying on that? But 5 days after the bill of sale, supposedly Lending Club gave it to Galaxy, who can now sue. They can't. They effectuated this sale, but it gets worse. This is the fun part. They're admitting, WebBank's admitting they're putting it in a Solar Gray Trust. So how can they give anything to Lending Club if the dates were switched and it was appropriate? They can't. So this thing's in a trust. And until you see an assignment of your client or you, an assignment with your name and account number in it going back to WebBank, who then sends the debt to Lending Club, who then can give it to Galaxy, which, by the way, also has to have an assignment or bill of sale with the account number and the debtor. None of that exists. It's just great. I hope you're turned on by it as I am. So as of January 27th, 2021, nobody's given anything to Lending Club because they admit themselves it's in a trust. Let me just see something. Lending was a servicer. In this role of servicer. Yeah, the next one doesn't help them at all either. So that is fantastic for you. Their own. By the way, what's the rule? Bing, 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 bing. Use their own documents against them, right? I can't think of anything better. So this is your securitization assignment video that is so cool and obvious and helps you, I hope. By the way, the loan, as I've put down, the loan was signed in 2/17/2020. That'll be in the notes. I won't put everything up on the screen. As you know, when you are a member of my membership site, Collection Stopper Solutions, you will have the video and all the paperwork. So attached to the video, I'm going to give you their actual lawsuit, my actual answer to this, and also a word template of my answer, a word template of my affirmative defenses, a word template of the counter affidavit. So this is, you can capture it and apply it to the state that you are in. I'm not telling you how to practice law or your life. Your rules may be different, but you've got this template now that you need. And that's all attached to the membership website along with this video. But guess what? There's more, because on the screen, Shazam, choice of law. See that choice of law? We are located in the state of Utah. This agreement is entered to in the state of Utah. Remember, WebBank's out of Utah. And funds for loans are dispersed from Utah. So what are they saying that for? They're locking up the genesis or the beginning of this origination. And they're saying the provisions of this agreement will be governed by federal laws and the laws of the state of Utah, to the extent not preempted, without regard to principle of conflict of laws that would require or permit the application of laws of a jurisdiction. Essentially, they're locking up the ability lawsuit to be filed anywhere else but Utah. And they like the Utah rules and laws. There's something favorable there. Well, that's why they're operating with this, what's called fintech. How do I put this? Fintech provisions and loans, as they get favorable non-usury protection rates that then they get out of the state and apply these kind of usurious rules and rates in states that don't allow that. It's an end around the usury laws of other states that perhaps Utah is more flexible in. So this has got to be in Utah. This case was filed in Michigan. Do a little bit of research on fintech. It's the future. That's where all or most debt is going to start coming from. It's going to beat your Discover and your Credit One or your Cap One. This is going to be the new debt, fintech debt. So all of the above ends up in your answer. Let's look at the answer. I'm going to try and do is put the first page on the screen, Shazam. So everything I just told you, for example, number one. So when you write an answer, you take the allegation that you saw from your lawsuit, or in this case, from this lawsuit, and number one says, you're this. So I put, I deny this, whatever they say. And by the way, there's no proof Galaxy owns this debt. And that dominates every answer allegation. Number two, whatever the question was, I neither admit or deny, and there's no proof as to plaintiff owning the debt. And then I cite my exhibit. So I'm supporting what I say. I don't just put exhibit B, you go check it out. You don't either. You give the court a good flavor of why you don't owe this debt and why you're being sued improperly. Number three, denied as to this plaintiff, and there's no ownership. And then that number four, where they're saying we got the debt without saying who gave it to him, any investors, any securitization. I go deep, man. Look at this. Everything I just said about Solar Gray Trust, it's in there. It's in number four, including exhibits 1 through 3. My allegations, this trust was conveyed all rights, title, and interest. We're using their words and documents against them. And I say, without any incitement of the debt back from the trusted lender, WebBank, further complicates any claim of direct ownership by Galaxy. It does. So you're going to shine with this bad boy. You can use, in your specific factual scenario, this as a template. But I lay it right on the line. Everything I just said to you, put it in your answer. Educate your judge, because their sterile, benign nothingness is not proof. Yours is. And will be the basis of a counterclaim, as I'm going to show you at the end, if plaintiff does not come up either with a settlement or a good offer to make that can start the settlement discussions. So number 5, number 6, you see number 6, I went deep and I included Green versus Portfolio Associates, and you should too. Read that case. It's everything you need. Number 7 is the same thing. I quote the cases above and say they don't own the debt. And by the way, I say, who the hell are the investors? And that's a great question. You can win that just off the investors. If you didn't find anything else, and you go to court, hey, yeah, Your Honor, we agree we own this. If you can just show me the assignments from each, and there's about 150 of them, investors assigning to and from. So you're going to win that. And what I did, someone asked me about affirmative defenses, so I'm going to Boom, make sure that's up there, affirmative defenses. And look at that, number 2, no standing, as without any assignment or transfer proof of the assignment. And that's the key. And I mentioned the trust, I mentioned web bank. The key is standing. If you don't have standing, meaning you don't have ownership or the right to sue someone, you can't sue someone. You've got to have standing. So, and there's my choice of law provision. I mentioned it. This is what you do. It goes in your preliminary statement. It goes in your answer. And of course, what does it go in? Again, you're on top of this. Your counter affidavit, which follows you for as far as this case goes. I think you'll see in the special email I'm going to show you that I have mentioned specific attachments to the attorney that I'm saying, you better get out of this. By the way, when I sent that email saying you better freaking walk away from this one and let my client go, he got back to me within minutes saying, we're working on this. I'm going to give it to my client. Just hold on. So this stuff works, man. So you can see through the affirmative defenses as I'm scrolling through them, and we're going to put each page of the affirmative defense on so you can see that clearly what I say is what I write. That's your demonstrative evidence. You can show a court just an answer. Go, Your Honor, just look at Exhibit 1, the affidavit defendant, or Exhibit 3, the fintech analysis that I gave you, or Exhibit 2, Green versus PRA. Your Honor, that's it. They didn't have the goods. And then Shazam affidavit of my client. And that is everything I just said to you in your affidavit. And as I'm scrolling, and I want to go to the third page here, and Shazam, you'll see I've put in some of the signatures to give the court a flavor, exactly all the entities, just 10 of them, when there's like 150 signing off. And I put in there, I teach the court. By the way, as I develop, and you may like this too, as you're writing, you're learning. Like I came to this after filing the answer, after doing this, I kept rewriting the draft because even now when I was doing this preparation for you, I found something else that I didn't see before that I wish I put in. There's so much here for you to win, for my client to win. So this is a great example of a securitized debt, as to use their words, from origination to now, where it completely trips them up and the plaintiff suing my client is not the right entity. It should be the trust, but that's long gone. So that's why I went back to Galaxy today. So now what I will put up is the actual email with protections that I sent to the other side about this. So you can see how I come in on them. And I've mentioned this, especially in default and garnishment motion to set aside videos. You don't necessarily want to go to court. If you can work it out with the other side, then you avoid the judge who may be a Nimrod going, yeah, but she took out the loan. Yeah, but they don't own the debt, so they can't sue. Yeah, but did she make payments? Like, you don't get into this. That's a bad deal there. So this is the email I sent to the other side's attorney. If I sound a little harsh, you kind of have to do this because they don't respect you unless you want to beat them over the head and they know it. I've beaten people over the head for so long. I don't necessarily they just see my name now. I'm not bragging. It's the only thing I'm good at. And they just go, hey, Parker, hold on. Not all law firms do that. Some will go, it's just Parker. And they go fight me. But the majority, and that's a value to my clients, just say, let me get to my client and I'll get right back to you. So here's the email that I sent over. I shouldn't do this, but I'll give you the email, Shazam. I'll leave the time, a date when I sent it, and then I'll just quickly put up the email of when they responded. That's how cool that was. And you, as an attorney, you get to go, look, this ain't false. What I'm talking about is real. Look how quickly they got back to us. So Shazam on that. You may see stuff in my email, and that's the reason I'm giving it to you, that you can use when you communicate with the other side in these kind of debt situations. Because I've got videos on how to settle a debt, how to talk to a collection attorney. Those do involve emails to the other side and being strong and setting the tone. You may recall in my how to settle a debt, let me just put it up, or how to talk to a collection attorney. I'll put that box up there too. You have to set the tone, because right now you're victimized. You're a victim of their belief that you owe it, therefore you're a bad person. So emails like that are necessitated by my need to turn this around with my name and who I am and what I do, and also with the facts, because I could suck. If I've got great facts, that's what's going to make the day. Great cases means great facts and great law. Combination, real funny expression of a trial attorney. He says, or he or she says, if I got the facts, but I don't have the law, I argue the facts. If I don't have the facts, but I've got the law, I argue the law. If I don't have either one of them, I just make it up. That's a paraphrase. Some attorneys are so good in court, they can make it up and just wing it. I've always wanted to be one of those. Not making it up, but like when I'm in trial motions, I don't like to read the stuff. I like them to know it's up here. And the minute they go to their reading, I'll point it out. Your Honor, he's reading this. I'm going to tell you from the heart. Okay? Whatever. All right. Thank you. If you like this and not this, but you like the information, go check out the membership website, collectionstoppersolutions.com. It's got a ton of stuff for a minimal price, and you get everything. I think it's 120 videos plus all the associated templates. I don't like to plug, but I really think it's a great deal. So go there. Again, you'll have these templates attached to this video. This video was more verbal than it is template written like it normally is, but there's enough there for you to do the job, and I hope it's good for you. Like, love, subscribe, check out the membership site, and I hope this is good. And as I always say, don't hesitate to ask me questions by my email if I didn't touch upon something or you want a video. Thank you very much. Have a good day.